Welcome back to Brashenomics. I'm Ben Brashen, and John Hugg joins us again. John, welcome back.
Thanks for having me back.
How are you today?
I'm doing okay.
Good.
Tax day, so I'm not always 100% happy on that day.
Did you write your check?
Not yet. I'll do that after I'm done.
It's en route. John, so, you specialize in estate planning, business succession planning, elder law. You speak a lot on those issues kind of around the greater Seattle area. And, I think there's an element that people don't always understand why this stuff is important, even if you don't have a lot of money. And, talk a little bit about maybe what should be driving people or what should be motivating them to go out and maybe take the time to get these plans in order.
Mm-hmm. Well, I guess the big thing that everybody should be paying attention to is, like you said, even if they don't have a lot of money, just getting everything in order to make everything easiest for your family. I mean, after things happen and whatnot, that's not the time to be trying to figure it out and sort it all out. You want to put everything in place up front so you know exactly what's going on, and so that the people who actually have to step in and take care of matters, they know what to do. They're not fumbling around. It's complicated enough as it is. So it's good to have everything put in place in advance, everything spelled out. And that's why you want to put together your estate plan, your wills, your trusts, your powers of attorney.
And that all creates basically an estate plan at that point in time, right? I mean,
correct. Yeah, the will and the trust, those concepts are, those are two building blocks of your estate plan. And they're used, and the concept comes up after you pass away. There's nothing that happens with the will or the trust before that event. But the estate plan can be broader and include powers of attorney, healthcare directives. Those things will be used when you're still alive. So even if something happens to you, you can still use those documents to take care of matters, again, when you're not able to take care of yourself, or you're still alive, you're not dead yet.
So talk about, maybe more specifically, a power of attorney, because basically what you're doing is what? You are giving somebody else your legal, your hand, your pen, your signature.
Exactly. Yeah. So with the power of attorney, you are basically granting authority to somebody else to act on your behalf and to take care of your affairs and make decisions for you. The different things that you'll be giving them power to deal with would be to buy and sell real estate, or deal with the personal property, handle bank accounts, pay the bills. It would be even broader, so they could maybe bring a lawsuit on your behalf if that's necessary, or defend a lawsuit, other things that can be done with the power of attorney. And you want to make it broad enough, because when we're talking about the estate planning context, you want to be broad enough to be able to cover basically all of those issues that you could do if you were still able to do them yourself. Because we're trying to, at minimum, one of the goals is to avoid a guardianship proceeding. You want to avoid the cost and the hassle of having to go to court and having the court sign off on everything. So you want to have the documents in place and the people in place that can carry out those activities without having to basically run in and get approval every single time.
And this makes it, as you said, a little bit easier on your caregiver, on maybe your husband or wife, or on kids, because it's I guess it would alleviate a big argument potentially.
Well, yeah, that's one of the goals, certainly. If you don't have any of the documents in place, if you don't have, say, the power of attorney in place, then something happens to you and you're not able to take care of your affairs, then again, you've got to run out to the attorney and find one that handles this type of work, and you go through the proceeding and have a competency hearing and whatnot, and move through everything to get yourself appointed, and then you'll have to have continual overview and oversight. So this is a way that for a whole lot less money, and a whole lot less hassle,
and stress.
Stress
with somebody who's maybe incapacitated,
mm-hmm.
that's hard enough.
Yes.
Without trying to legally go through the hoops.
Right. Absolutely.
To help them.
Yeah, and I sat down with a client last week, and fairly elaborate, estate plan, but the bottom line, the key that I took away from it is what they repeated over and over again is make it as simple as possible. Make it so that so that everybody understands what's going on and it's just going to, one thing after another is just going to happen without problem, without hassle, without a fight, and without issue.
How would you recommend somebody go about getting a power of attorney? With their family, with people?
Well, it depends on the situation. So if you're a younger individual, usually, a husband and wife will come in, sit down, and we'll start talking about their entire estate plan. We'll start usually with the will and what they might need there, and then I almost always, not almost always, but always, then say, okay, well, what about a power of attorney, healthcare directive, those related documents? Sometimes they've thought about them, sometimes they haven't, but we then segue right into that. With older individuals, a lot of times they come in with their children, or a meeting with all of them, the children, or at least one child, and the parent.
The kid they plan on trusting.
Most of the time, yeah. Not all the time.
They leave home the bad apple at home, right? Or no, you don't need to come to this meeting.
Yeah, well, sometimes that, although sometimes it's everybody. And that works very well. So everything is out and in the open, and you start talking about it and how you're going to handle all that stuff.
And so what are some key points to really be aware of? When you start going through this process of an entire estate plan, really?
Well, with the estate plan, I guess the most important thing is the selection of the individual that you want to have making these decisions. Who's going to be the executor of the estate? Who will be the trustee? Who will be the guardian that will raise your children? And with regard to the power of attorney, who's going to be acting, on your behalf? And it's not always as straightforward as you might think. For me, it's fairly simple. I would, choose my wife no matter what. I'm absolute confidence that she would take care of me. I'm not saying that just because I know she's listening, but I have absolute confidence that she would take care of me. But that's not always the case. I have a client. He's here. His wife is in another state, so she's not the first person that you would think of to put in that position. And other situations where you have one spouse who isn't doing as well as the other spouse, that one spouse who is maybe failing a little bit, obviously not the first person, so you're looking at children in that case, and then again you have to kind of sort through who's the best person.
So there's almost this inner hierarchy of people that you may select based on competency.
Exactly, and a lot of times too, and that's a really good point, because a lot of times we'll do two separate powers of attorney. We'll do one for financial decisions, we'll do one for healthcare decisions. One of the things that drives that, is two different people. Well, we have a lot of confidence that one child, and usually it's a child situation, one child will be able to handle the finances, but not so much confidence that they will be able to follow mom or dad's wishes when it comes to end-of-life medical decisions. But then some other child in the family maybe is a nurse or is a doctor or has some more experience with the medical field, and they feel much more confident that they will be able to make those decisions appropriately when the time comes.
So it really comes down to, appointing the right people in a lot of ways. It's not just, you made some really big points. Who's really going to take care of your kids if you die? Who's really going to take care of your money? These are things that, and I'm such a big advocate of having a professional help you. These are things that you don't get a good dialogue going online and just clicking, oh, Susie, oh, Bill, oh, right. We're going to give them to the neighbors, who's going to get the dog? I don't know, right? So these are certain, I think it's such an important dialogue to be able to have with somebody who's done it before.
Absolutely. And I think a lot of the clients that come to me when they've started online and they come to me, it's always actually more work because they've already started down a particular path. A lot of things that, then popped up. They thought they knew the answers to these questions. And then, there was a prompt in the, online that they didn't know how to answer, and they get frustrated with it, and then they go to the attorney and then
it's the fix it. I don't know, but I read this.
Exactly. And there's a lot of things that are very practical that I think a lot of people don't really think about. I've got so many situations where you've got siblings sort of at odds with each other. They haven't been at odds before, but now you want to think about that. So I bring that up because a lot of people ask, well, can I have both of my kids be co-executor or co-power of attorney? Well, technically, yes, but maybe that's not the best thing, or maybe it is, depending on the circumstances. And those are the things that the lawyer is going to bring to the table, that experience and that knowledge of those different things that arise or have arisen in the past that have led to problems.
Right, and I think that could be such a huge advantage to just know. You know, it's easy to just click both names, but hey, look, this is kind of what's a horror story, or what's a story about that not going right when you have people who are both going to be in charge.
Well, actually, some of my horror stories are actually not with that. So again, it's one of those things where you kind of have to think about how everything is going to unfold. I have some clients where I think one person expected that they would have more say at a certain point in time, and then when that time came, they found that they didn't really have any say, and so that created a lot of animosity. The other person maybe wasn't the best person to select, but for whatever reason, they did select that person to act for the parent, and now it's just a constant. Well, they did this wrong, or they did that wrong, and can we do this? Can we go after them for that? It's like, and then those are some of the
tension gets high, emotions are running high.
Exactly.
We're here with John Hugg, attorney with Hugg and Associates. John, what are all the powers that you can give out? When you talk about finance, pulling the plug,
right?
What are they? I mean, is there just a laundry list?
To a degree, there is a laundry list that you're going to follow in general. So with regard to, say, real property, you're going to give them the ability to purchase real property or sell real property, make a gift of it, mortgage it, pay off the mortgage. Same type of thing with personal property. If you usually in terms of giving it away or doing something with it or selling it or whatever. Same types of things with brokerage accounts, the ability to trade within the brokerage account, get money out. Certainly going to address paying bills and things like that, making sure all the regular bills get paid. And then all of the medical stuff. It's important to think about the medical aspect of things as well. And that's not an exhaustive list, by the way. You can give a lot of other things. Actually, what you can kind of do is work in reverse and say, well, here's the things that you can't normally do, which is you can't give away the power. And, well, you can. Actually, you can override it. But state law says that generally the power of attorney, the attorney in fact, who's acting, can't change your will, can't change your beneficiary designations on your life insurance, your IRAs, and things like that. You can override that if you want, although I don't think I've ever advised that you override that.
And that's when, like you think about on TV, I'm not giving you the house in Jamaica. I'm just reading the piece of paper.
Right. Yep.
Well, John, thanks so much for joining us. We do have to go to break. And when we come back, Paul Pukas is back with us, who is a speaker, co-author of a book called Protect Yourself, which is kind of just a perfect run-in because as people can get in trouble trying to do their wills and powers of attorneys online, insurance is just the exact same thing. We'll be right back after this break. That's John Hugg. You're listening to Brashenomics.